Is Damon Ritenhouse from EV Law Group, and later we'll be joined by another attorney from that group. Damon, welcome.
Pleasure to be here, Kelly.
And you're here to talk a little bit about foreclosures.
And specifically tenants in foreclosure and how they're affected, what their rights are, things like that.
So, what is a tenant in foreclosure?
A tenant foreclosure is somebody who was a lawful tenant in a building. They had a lease, they were paying their rent to the landlord, and then through no fault of their own, the building went into foreclosure. The owner had stopped paying. The bank eventually takes it back over, and they're kind of stuck in limbo. They don't know who they're supposed to pay, if they have to leave immediately. Sometimes they get notices that don't make a lot of sense to them. And it's important for people to know that there are rights and protections both on a state level, federal level, and at the local level here in Chicago.
So, as a tenant in foreclosure, I might be someone who is paying my rent, lawfully occupying this building, no differently than any of my neighbors. I don't have anything to do with not paying the bank. I haven't breached any of my responsibilities.
Correct. Yeah, usually, again, it's the owner who's the landlord who has gotten into trouble or for whatever reason has stopped paying. And, as long as the tenant is doing what they're supposed to do, and most people are, they're kind of in a blameless situation, but unfortunately they get caught in the aftermath when the property's sold, and sometimes they're confused about where to go, who to talk to, what they're supposed to do.
Do I have a right to know about the foreclosure, about the fact that it's happening?
You do. Under the Chicago RLTO, the ordinance that protects tenants, owners of buildings do have an obligation to make their tenants aware of foreclosures. Unfortunately, that doesn't always happen. Sometimes tenants find out through other sources. Real estate agents come by, they see notices posted, they see court papers in the mail, they go online. But they do have an absolute right to it. Unfortunately, they don't always get that information in a timely fashion.
Now, does the bank, it seems like the bank should do so much that they don't do. Is one of the things the bank should do is name me as a defendant? Do they have to name me as the tenant as a defendant?
No, they don't have to name tenants in foreclosure actions. They're not necessary parties. So, chances are if you're a tenant, you're not going to get notice. You're not going to be a named defendant in court. So it's very possible the whole court process can go by without you having notice because the bank's not obligated to name you. They're only obligated to name the person who owns the building.
So, what are my rights then if my landlord doesn't pay their mortgage or is accused of not paying their mortgage and doesn't properly defend the case? Will I eventually lose my housing? What will happen?
Well, the first piece of advice I give to tenants is always track your payments, and you want to have proof of payment. Some people pay in cash or they have other arrangements with their landlord, and that's fine as far as it goes. But it becomes very important, excuse me, when you're a tenant in foreclosure to be able to show that you have a real lease and that you've been making payments and who those payments have been going to. If you can do that, you're in a position to protect yourself. From there, there's a new Chicago ordinance that if you can show you are a bona fide tenant, the new owners of buildings are obligated to either honor your lease and renew it annually with no more than 2% increases, or pay you a relocation fee, which I believe is $10,000. It may even be a little bit more than that, in order to give you the ability to move. It's important that you know those rights and that you talk to an attorney who can also help you take care of those rights
So I
in
should
court.
quit paying my rent and just collect $10,000.
No, I would not advise that. You want to make sure you're paying your rent to the person who it's owed to. Now, where it can also be difficult is from the time period when your landlord loses control of the building to when you get this notice on your door that says you have to get out. Sometimes you want to pay your rent and the banks make it difficult. They don't help you. They won't let you know where to send your rent. You want to make every attempt to find out where to send your rent, escrow that money if they won't accept it, document everything that you're doing what you can and you're trying to honor your side of the lease.
What does escrow mean?
Escrow means that you're setting that money aside. Now, whether you're doing that, in a separate savings account, or better yet, if you've got a lawyer or a community organization or somebody that you trust to hold that money for you, so that when it does come time to go to court or talk to a judge, you can say, Your Honor, I've been setting aside, now I've got several $1,000s. I wanted to pay this. I'm able to pay it. I'd like my lease to be honored.
Okay.
That's my best advice to tenants who find themselves in that position.
And how long does the landlord have to let me stay? Do they have to renew my lease?
Really, the where it turns, as I understand, on the new Chicago ordinance is that you have to show you have the bona fide lease, like I talked about, so that the lease is in effect and that you've been paying. If that's correct, then they're obligated to renew it. There's also federal and state protections where at a minimum they have to give you 90 days notice before they're going to institute any eviction action against you. So from the time that the landlord loses control of the building. They have to post a notice and sometimes serve it and make sure that you get a copy of it that says for 90 days we can't do anything as far as court action. And ideally, they're giving contact information for you to reach out to them and say, hey, I am a tenant. I do have a lease here. I want to honor my obligations. Again, that doesn't always happen, and that's why it's important to not only know those rights, but be able to find a lawyer or an organization that can help you protect those rights and vindicate those rights in court.
So again, this is Resistance Legal Clinic, and we're taking your calls at 738-1060. And we're with Damon Ritenhouse, the EV Law Group. I'm Kelly Dudley. What about people who are from right outside Chicago? Someone in Maywood or Oak Park. They're not maybe is immediately protected by the RLTO. Do they have any rights?
They do. They're still protected by what's called the Protecting Tenants and Foreclosure Act, which is a federal act. That's in effect through the end of 2014. So we've got about 10 or 11 more months, and that's due to sunset. But right now, there's still protections, and that's where the 90-day time period comes from. There's certain requirements that the lender has that they have to notify you. There's also a new state law that's come into effect dealing with tenants that kind of supplements the Protecting Tenants and Foreclosures Act and hopefully is going to stand in and maybe improve on some of the areas where that hasn't been strong. Again, the key is knowing those rights, but it's also important to find someone who can help you enforce those, because it's our experience that the banks, the lenders, their agents don't always do what they're supposed to do. So you need help asserting those rights in court and figuring out what those violations are and helping you ultimately protect your home.
What would happen if I was in my home paying my rent, didn't know anything about a foreclosure, or if I did know something about a foreclosure, I wasn't a party because I was just a tenant,
Sure.
and the Cook County Sheriff shows at my door with an eviction order? Can I be evicted?
If it's an eviction order that has another person's name on it, they should not be able to evict you. So it's important that you have a copy of your lease handy, copies of utility bills with your names on it, an identification card or a license with your name and address on it. Generally, in our experience, if you can prove those things, then that identity, the sheriff will not evict you. Because most likely the name on the order of possession that they're trying to enforce is the name of your landlord or the owner of the building and not your name, if that's an order of possession from the foreclosure court. Now, if there's been an eviction action, a separate eviction action filed where they name you as a tenant, it's important to go to court, because if the sheriff comes with an order of possession with your name on it, you may have a harder time telling him or her that they don't have a right to dispossess you of the property. So it's important, if there are court dates where you're named as a defendant, that you attend those, that you get a lawyer, that you make sure you're asserting your rights in those instances.
I think some people, too, when they get the notice on their door that says there's going to be an eviction,
Sure.
and they know that they haven't been named, it's just their landlord,
Right.
they've been going to the 7th floor of Daly Center, if it's here in Chicago, here in Cook County, and they've been talking to the sheriff
Right.
and letting them know about the situation. And I think they've had good luck with having those evictions called off, working with groups like Communities United Against Foreclosure and Eviction, or the Chicago Anti-Eviction Campaign, or Centro Autonomo, all of whom have been guests on the show
Sure.
at various times.
My experience in talking to tenants is that the sheriffs have been pretty understanding about what's going on, and as long as you can prove your identity and your right to be in that property, they've been pretty reasonable about it. So I think it's a good idea when you get those notices to be proactive and go talk to somebody at the sheriff's office, bring your documents with you and explain to them what's going on. And I think people have had success doing that, as well as consulting with attorneys.
I think sometimes, too, the banks, in an effort to do an eviction action against people, come and ask people their names.
Sure.
Or the name of everyone who lives in the building. And of course, I can't speak for every person in Chicago, but it seems to me that we all have memory lapses.
That's true.
And there are certainly days that I can't remember my name.
Right.
That's a lot of days,
Right.
actually. And I would just, you're not under any duty, I would say, to provide your name and information, or the information about people living in your property, to some third party who just comes and knocks on your door.
Right. I think that's correct. I mean, unless it's a police officer or a sheriff's deputy, you have no obligation to tell anyone your identity. Obviously, that's your choice, but there's usually not a benefit to be gained from giving information to people who are probably not looking out for your best interest.
Right. Although we'll have to give them our name when we sue them for violating the Fair Debt Collection Practices Act.
Right.
But
Yes.
that's down the road.
That comes later down the
Or
line.
the
Yeah.
ordinance you mentioned. Do you see very many cases where people are living in a property, it does go into foreclosure, And then some of the banks or firms don't always respect people's rights under the Chicago Residential Landlord Tenant Ordinance or the state and federal laws that we've talked
Sure.
about.
Yeah, I mean, we've seen cases, where the proper notices haven't been posted, evictions get filed prematurely, sometimes while there's leases that are existing. We've seen things as egregious as people getting locked out, locks being changed, things being taken out of the unit. So it really runs the gamut from, the kind of technical violations, which are still violations and are illegal, to, people who are not sheriff's deputies and have no right changing locks, taking property out, threatening people, things of that nature. So there's a lot of violations, and there's a lot of trampling of rights of people who are in these units and these properties that have every right to be there, but those rights are not being respected by the bank or the people that they hire to manage these properties.
Now, actually, a lockout is always illegal. And
Right.
people should contact an attorney or one of the community groups if they experience that. And by lockout, I mean a wide range of behaviors without an eviction order and without being done by the sheriff. So there are two elements to a proper eviction in Cook County. One is that you have to have a court order signed by a judge, and it has to be executed by the sheriff. We don't have evictions by thug
Right.
in Cook County. We do have them. We don't
They're
have
not
them
legal.
legally.
Yes.
And so what has to happen is that the sheriff comes and follows a little bit of the process that we've talked about today. But sometimes people come home and simply find their door locked, or they come home and find that their things have been removed. The door has been taken off the hinges. And another common form of an illegal lockout is turning off the utilities.
Right.
So you don't have water, heat, electricity, the things you need to comfortably occupy the apartment if those are under the landlord's control. All of that's illegal. And in addition to calling an attorney, a community group, they also need to call the Chicago police, because the RLTO says that the police shall
Yes.
investigate illegal lockouts. And sometimes the police officers responding don't know that, and it can be very handy to have a copy of the Chicago RLTO at hand.
Right. And we've had cases where that's happened before, and when I talk to a client or a potential client who that's happened to, I say that's breaking and entering, that's possibly a burglary. I mean, those are, we're not just talking about technical violations a lot anymore. Those are potential felonies when somebody who's not a law enforcement officer is forcibly entering your home without the right to do so. So it's very important to get the Chicago police involved, as Kelly mentioned, and that not only talk to a lawyer, but make sure you have that police report on file, and that can become useful further down the line, if there is liability against these banks or their agents.
And sometimes, as I said, the police officers don't understand that, haven't been taught that or provided the information. A lot of tenants don't know, so certainly it's not asserted very often. It's important to get in touch with somebody who can go to a police station with you with a copy of the RLTO. I know Communities United Against Foreclosure and Eviction and Chicago Anti-Eviction Campaign and Centro Autonomo have all been involved on that in some level. And I would presume that the Metropolitan Tenants Organization would at least have some helpful information.
I would think so.
So here pretty soon we're going to switch over and we're going to talk to your colleague at EV Law Group, Faisal El Khatib.
Mm-hmm.
Before we talk to him, what else would you like us to know?
Well, I think Kelly and I have covered the basics here. Again, if you're living in a building and you get any indication that your landlord or the owner of the building is getting behind or that he's having trouble, if there's real estate agents coming around, if anything starts to kind of smell wrong to you, the earlier you can find out what's going on, the better, before, somebody is coming to your door or somebody is changing your lock. So, if you're in a unit and doing the right things, that's great, keep doing them, but be proactive if things start to feel wrong about what's going on. And, always document your payments, always keep copies of your current leases, just be ready for anything when you're in that position, because fortunately the onus is on you to protect your home. There are resources out there, and I hope that you can utilize those, but you have to be proactive as a tenant.
Absolutely. Well, thank you for joining us. I
Thank
hope
you
you'll
for
come
having me.
on again.
Absolutely.